Let's discuss the difference between a revocable trust and a will. A will is a legal document that outlines how your assets will be distributed after your passing. However, it must go through the probate process. During probate, a court verifies the will's validity, settles debts and taxes, and distributes assets according to its instructions. Unfortunately, this process can be time-consuming, costly, and become a matter of public record. On the other hand, a revocable trust, also known as a living trust, can help you avoid probate altogether. It's a legal entity created during your lifetime to hold and manage your assets. When you pass away, the assets held in the trust can be distributed to your beneficiaries without going through probate. This helps avoid the time and expense associated with probate and provides for a more private distribution of assets. With a will, its contents, the value of your assets, and the identities of beneficiaries become accessible to the public during probate. Since the trust doesn't go through probate, its contents and beneficiaries remain private. Regarding flexibility and control, a will allows you to appoint a personal representative who will carry out your wishes and distribute your assets. However, please note that a will only takes effect upon your death and can be revised or amended as long as you are mentally competent. With a revocable trust, you enjoy more flexibility and control over your assets during your lifetime. As the grantor, you can serve as the trustee and maintain control over the trust's assets. You also have the freedom to change or revoke the trust terms or appoint a successor trustee to manage the trust if you become incapacitated or pass away. A will does not provide any provisions for managing your assets in the event of your incapacity. If you were to become incapacitated, a court-appointed guardian may be required to manage your affairs according to the court's decisions. However, a revocable trust includes provisions for managing your assets if you become incapacitated. Since you serve as the trustee during your lifetime, a successor trustee can step in to manage the trust's assets if you are unable to do so. A will only governs assets solely owned by you in your individual name. Assets held jointly with rights of survivorship, or those with designated beneficiaries, for example, life insurance policies, retirement accounts, pass directly to the joint owner or designated beneficiary and are not controlled by the will. To have assets governed by a revocable trust, you need to transfer ownership of assets to the trust through funding. This process ensures that the trust controls the assets, allowing for a seamless distribution according to your instructions after your passing. Estate planning can be overwhelming, but understanding these differences may help you make the right decision for your unique situation.